Still Waiting in Rockford, Michigan. And Still Waiting says, I just paid off my home and the mortgage was with a private lender, a person.
Mm-hmm.
What documents should I expect from this private lender and what should I get recorded with the county? Still Waiting in Rockford, Michigan. This is a good question. Good question.
Right. I mean, this is where, pardon me, we're still cleaning up, believe it or not. We're in 2021 right now. But we are actually still cleaning up after the mess that was left from the foreclosure crisis and housing crisis of 2008. And what that is there are a lot of mortgages. Well, first of all, there are a lot of mortgage companies that went out of business, right, in the mid 2000s with the Great Recession. For those people who are in their 20s, they were only like 10 years old or whatever. But there was a huge meltdown and it impacted so many people. So one of the things that becomes problematic is if a home wasn't foreclosed upon, but it was paid off, a lot of the mortgage companies that were obligated to provide a mortgage discharge, that is the required document, that needs to be released and needs to be recorded by the lending institution, whether it's a bank, a credit union, a mortgage company, and a private individual. If you make a loan and you have a lien on the property, the state of Michigan requires that you discharge your mortgage. You record it, and you do not charge your mortgagor, your former mortgagor, a fee for that discharge. Okay, you have to record the discharge. Now, I do know a lot of private lenders, because we represent quite a few, will send the discharge to the client and say, thank you very much for the payoff. Here you go record it. That's one of the things, that's still a discharge, but it really isn't recording the discharge. Okay. And so what happens is like a homeowner, they pay it off, they get it in the mail and they're happy. They go, oh, I'm done. No, that's, you're halfway done. The next step is to go get it recorded. I actually believe, I'd have to look at the law, but the law is a discharge needs to be executed and provided to the mortgagor. Okay. I don't think it says it has to be recorded. But if you are going to record it as the lender, you can't charge the client or the mortgagor a recording fee. Okay. It's not right. So that's what these people would be looking for, is the actual mortgage discharge. Okay. And if you don't have it, and whoever's watching, I mean, if you paid something off and you're not sure, pull title work, call down to the county, because as time progresses, the people who you're dealing with, especially in a private lending situation, that person, God forbid, could become ill, it could become sick, they move out of state, you no longer can locate them. You know how difficult it is to then prove that you paid somebody off? You now have to, a lot of times, and we have quiet title actions that deal specifically with the fact that a lending institution did not release a mortgage. That's it.
No, yeah. And so not all private lenders know exactly what their protocol is either. Not, just because someone is willing to give you a mortgage on the property doesn't mean that they understand at the end to A, discharge you, and B, record it with the county. So you just want to be really diligent and advocate for your own self. And that's a question I was going to ask you, is how can they verify so they can have title work pulled? They can just call the county.
You can call down to the county or register wherever the home is situated is where you need to get that discharge. Okay, in that county register of deeds. We often, Blair, will, like at night when we do these, today is we're doing in the afternoon, but we usually go down these rabbit holes, and I hate to do this to you, but I just want to kind of elaborate a little bit further on this. It's not just mortgages. If you have a lien on a piece of property and it's not a mortgage, you file a lien, it's the lien holder's obligation to provide the discharge, okay? When whatever that lien is satisfied. And for the audience, for the people who watch this, mostly real estate investors who deal in land contracts, I will often get the question, usually from out-of-state investors, hey, how do I discharge my land contract? Well, it's pretty simple. If the parties have completed a land contract, the land contract buyer has fulfilled their obligation, there's no need for a discharge. Instead, what we're looking for is the actual deed, right? Because the deed is the evidence that the parties completed the transaction. So all you need to do is have a recorded deed, whether that be the quitclaim deed or a warranty deed, whatever the deed that was called for in the land contract. That's what we need to see in the title work to show that the buyer completed the transaction, and that's it. So there's no discharge per se in a land contract transaction.
Okay, so for the land contract, you should have the memorandum recorded.
Oh yeah.
At the current point in time, and then once you have satisfied the contract or refinance out of the contract, then you now have to have the deed recorded instead of just that memorandum.
That's correct. Right, and that's how, you know, every week it seems the attorneys in my office and I were looking through people's titles and stuff, looking for the appropriate documents that should have been recorded. But it's kind of like, if you're newer to the business, just think that it's like breadcrumbs. You're always looking for, these documents are breadcrumbs. If they're not recorded with the county, a third party looking on cannot follow the trail of the title, of how title has been conveyed, what's the history of the title. So discharges, mortgages, land contracts, claims of interest, list pendants, everything that affects title, easements, utility easements, you know, right away easements, driveway agreements, there's private driveway agreements. There's so many things that get recorded. And the only way that you can put people on notice is of whatever these transactions are, is by recording the intent of the parties with these documents. And then the only way you know that the intent has either been completed, fulfilled, the obligations have been met, is when you have releases of liens or discharges of obligations, and those have to be recorded too. Otherwise, you have what we call a cloud on title. You don't have the discharge. You have something outstanding that still needs to be resolved. So that is the answer to your, well, a very roundabout long answer to your question. They usually are longer. We start with short questions, but the answers always seem to be much longer because there's so many different ways to answer it.
So for Still Waiting in Rockford, this was a really great question, and I'm glad that you asked it. I'm glad that you are advocating for yourself, and that's what I would encourage anyone in this situation. It may be the other party's obligation to fulfill X, Y, Z, but advocate for yourself.
Definitely.
Trust but verify that has been taken care of. Don't, you know, especially if you are not going to receive some sort of notification on the other end. The county isn't going to call you, text you, mail you to let you know that it's been recorded. You need to actually do your own diligence and follow through.
Right. Exactly. I do want to tell you, Blair, that we do on our website under the deed section, you know, on our website, we actually have a list of all the registers of deeds or recording offices for each county available with their numbers, phone numbers, as well as their emails, so that if you need to get in touch with your respective county register of deeds, it's a great place that you can go to. Yeah. So it's on our website.
Great. Okay. Awesome.
Proven resource.
Proven resource. Hence the name.